during the meeting.
Welcome to the Professional and Vocational Licensing Virtual Board Meeting.
When the meeting begins momentarily, the chair will take a roll call, explain any specific rules for this particular board, and then move to public comment. The name of the board member will appear on the bottom left-hand corner of your screen. For instance, this is board member Y, and this is board member E. Public testimony will be accepted at the beginning of the meeting and before each agenda item. You can indicate that you are ready to testify by clicking on the Raise Hand button being circled by the mouse on your screen now. At the appropriate time, the board will recognize you to speak and ask you to unmute your mic as shown here. Again, public testimony will be accepted at the beginning of the meeting and before each agenda item. Public attendees will not be able to unmute their microphone until recognized by the board. Public attendees who are recognized to testify will be asked to identify themselves by name and their affiliated organization if applicable. Please mute your microphone when you are finished speaking as a courtesy to others and members of the board. Public attendees will not be able to unmute themselves after the testimony is completed unless recognized again after raising their hand. At some point during the meeting, the board may choose to move into executive session. When the board moves into executive session, the board members' microphones and video feeds will be turned off, and a similar screen as you see now will be displayed. When the board returns from executive session, their microphones will be turned on as well as their video cameras.
Welcome again to the Professional and Vocational Licensing Virtual Board Meeting.
At this time, the chair will call the meeting to order and take a roll call, as well as explain any additional rules that may be specific to this board.
Okay, good afternoon. My name is Gary Belcher. I'm the Vice Chair of the Hawaii Medical Board. And the first thing I'm going to do is read a prepared script that describes the way the public can access and participate in this meeting. So to view the meeting and provide live oral testimony, please use the link at the top of the agenda. You will be asked to enter your name. The board requests that you enter your full name, but you may use a pseudonym or other identifier if you wish to remain anonymous. You will also be asked for an email address. You may fill in this field with any entry in an email format. For example, your name @gmail.com. Your microphone will be automatically muted. When the chairperson asks for public testimony, you may click the Raise Hand button found on your Zoom screen to indicate that you wish to testify about that agenda item. The chairperson will individually enable each testifier to unmute their microphone. When recognized by the chairperson, please unmute your microphone before speaking and mute your microphone after you finish speaking. For phone access, if you cannot get internet access, you may get audio-only access by calling the Zoom phone number listed at the top of the agenda. Upon dialing the number, you will be prompted to enter the meeting ID, which is also listed at the top of the agenda. After entering the meeting ID, you will be asked to enter your panelist number or wait to be admitted into the meeting. You will not have a panelist number, so please wait until you are admitted into the meeting. When the chairperson asks for public testimony, you may indicate you want to testify by entering the star sign, then 9 on your phone keypad. After entering the star sign and then 9, the voice prompt will let you know that the host of the meeting has been notified. When recognized by the chairperson, you may unmute yourself by pressing star sign and then 6 on your phone. A voice prompt will let you know that you are unmuted. Once you're finished speaking, please enter the star sign and then 6 again to mute yourself. For both internet and phone access when testifying, you will be asked to identify yourself and the organization, if any, that you represent. Each testifier will be limited to 5 minutes of testimony per agenda item. If connection to the meeting is lost for more than 30 minutes, The meeting will be continued on a specified date and time. This information will be provided on the board's website, and the link is available. Instructions to attend the Hawaii virtual board meetings may be found online at the website on the agenda. So welcome to the board meeting, Hawaii Medical Board meeting. At this time, we will take a roll call. So please indicate if you are present and indicate that you are alone. I'm Gary Belcher. I'm present and alone. Dr. Rick Fong.
Present and alone.
Dr. Elizabeth Ignacio.
Present and alone.
Dr. Angela Pratt.
Present and alone.
Dr. Rebecca Sawai.
Present and alone.
Dr. Jerry Young.
Present and alone.
Dr. Brian Hatton.
Present and alone.
Okay, everyone's here. So at this time, I'd like to have a motion to approve the meeting minutes from
Gary, I
October
actually
12th.
have an issue with the meeting minutes from last time.
Okay,
So in the matter of the application for Dr. Kozue Shimabukuro, I think both Dr. Hatton and I had recused ourselves from both the discussion as well as the voting that had occurred due to our employment at Kaiser Permanente. So I think that I didn't see that reflected in the minutes, but I don't think either of us had participated. And Brian, you can correct me if I'm wrong, but we didn't participate in that part.
I see that Dr. Hatton is agreeing with that. So the administrative staff can make those corrections. And Alani, can we go ahead and approve the minutes pending the corrections made?
So approve the minutes with corrections or revisions.
All right, we will, may I have a motion to approve the meeting minutes of the 14th of October with amendments per Dr. Sawai?
So moved.
Second,
Ignacio, second.
thank you. Okay, do any members of the public have testimony with regards to that agenda item?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Okay, at this point, I'd like to move into executive session. And I don't believe I need a motion for that.
So you will recess into chapter 91.
Okay. Let's recess into chapter 91.
So for the public's information, the board will go into a separate breakout room to discuss some of the chapter 91 matters.
Thank you, Alani.
You're welcome.
Okay, we're back in open session. Dr. Danny Takanishi, Oahu member and the current chairperson of the Hawaii Medical Board. And so what I would like to do is to quickly take a roll call, and please let me know if you are present and alone. And so Danny Takanishi, Oahu member, current chairperson, I'm present and alone. Mr. Gary Belcher.
Present and alone.
Dr. Andrew Fong.
Present and alone.
Dr. Elizabeth Ignacio.
Present and alone.
Dr. Angela Pratt.
Present and alone.
Dr. Rebecca Sawai.
Present and alone.
Dr. Jerry Young.
Present and alone.
And Dr. Brian Hatton.
Present and alone.
And I don't believe that I missed anyone. All right, so just to make two announcements. So on the matter of the physician's licensing of Thomas K.S. Knoll, the board did approve the settlement agreement. And on the matter of the license to practice osteopathy of Dr. Shannon P. Calhoun, the board voted to terminate the probation. And so now what I would like to do is enter into the matter of the physician's license of Curtis R. Beckham, MD, and the hearings officer's finding of fact, conclusions of law, and recommended order. So the way in which I'd like to proceed is to allow Dr. Beckham and or his counsel a total of 15 minutes to provide oral testimony, and then provide Rico the same privilege of 15 minutes, and then now allow each side the opportunity for 10 minutes of a rebuttal in the same order. So Dr. Curtis Beckham and or his counsel, followed by Rico. So at this time, I'd like to invite Dr. Curtis Beckham and or his counsel to please address the board.
Well, good afternoon. This is Bill Harrison. My video is not on. I don't have control of the video. Am I supposed to be on video or not?
Preferable, I believe.
Yeah, it'd be preferable.
Okay, thank you. I just got the notice I can stop my video. Okay, well, thank you. And I believe that...
Oh, I'm sorry, counsel, my error. What I think we'll do first of all is we'll have Rico provide their comments.
The conference room to zoom in on Ms. Yanashiro. Board members and Mr. Harrison, are you able to see Ms. Yanashiro?
This is Bill Harrison. Yes, I'm able to see her. Thank you.
Thank you.
Good afternoon, members of the board. Rebecca Yonashiro from the Regulated Industries Complaints Office, appearing on behalf of petitioner, Department of Commerce and Consumer Affairs. The state's position is that it stands on its pleadings, including its statement in support of the HORL. If the board has any questions, we can certainly answer those, but if not, let's take a step back and look at this case for what it is. Before the board is a tried and convicted sex offender in a position of power and privilege with an unrestricted license to practice medicine in the community, with unfettered access to women, children, and men, and with a record for practicing medicine outside of the clinical setting. In this case, respondent preyed on an older woman by offering to provide free medical treatment and then sexually assaulted her while they're alone in her home in 2 separate incidents, all under the guise of providing medical treatment and care. Respondent argued, quote, The logical question that needs to be addressed is, would anyone sincerely believe a young 47-year-old doctor would have any sexual desire for an ailing 60-plus-year-old woman? Well, the jury did, beyond a reasonable doubt, and after examining the evidence, including defense counsel's cross-examination of the victim, in which defense counsel attacked the victim's credibility and character, respondent's 12 peers still believed the victim and convicted respondent on 2 counts of sexual assault in the 4th degree. Respondent knew what he was doing. He preyed on a vulnerable person because who would sincerely believe her? Sexual violence is not necessarily about desire, but more about power. And respondent's convictions demonstrate respondent abused his power as a physician to harm another person in this case. Now, respondent has qualified his convictions and argues, quote, "These are misdemeanors, not felonies." And in doing so, respondent greatly minimizes the serious nature of the underlying conduct of his convictions. So let me clarify what this is. It is criminal conduct that violated another person sexually, that caused psychological harm to another person's well-being, demonstrating respondent's inability to manage his emotions and control impulsive behavior. It is criminal conduct that erodes the moral and ethical integrity vital to the practice of medicine, demonstrating respondent's failure to maintain the highest standards of professional conduct. It is criminal conduct that undermines the confidence and trust that patients and the public alike are entitled to expect from a physician, lowering the standing of the whole medical profession in the eyes of the public. These are not just misdemeanors. Respondent has also argued, quote, "I'm just a small country doctor. I don't have an ego." Yet throughout these entire proceedings, respondent fails to demonstrate any sense of remorse, that despite having been convicted of 2 sex assaults, respondent continues to take every opportunity to attack the victim and bash her character. Respondent has failed to accept any responsibility for his actions and continues to blame everyone but himself, from his former defense attorney, to the victim, to the state, to the hearings officer. And he argues and believes, quote, "There is a concerted political effort to get rid of me." Respondent fails to acknowledge any harm to the victim, to the medical profession, and to the community and society as a whole, who he owes an ongoing duty to maintain the highest standards of professional conduct. And finally, throughout these entire proceedings, respondent has continuously and callously disregarded the hearings officer's authority by ignoring multiple deadlines, instructions, and notices, and by disrespecting the hearings officer and the decorum of these administrative proceedings. Respondent is a convicted sex offender who lacks remorse for the harm that he has caused, who has an ego, and disregards authority, from procedural administrative rules to criminal statutes. And this predator is going into the most remote areas of Hana to render undocumented, unsupervised services and medication to the most vulnerable populations in the privacy of their homes. The board has an obligation to ensure only qualified and fit individuals are licensed to practice medicine, and by his conduct and convictions, respondent has demonstrated that he is neither qualified nor fit to do so. And for the board to order any sanction less than a revocation in this case signals to its licensees, to the public, to the victim in this case, that the Hawaii Medical Board, in its collective professional medical opinion, tolerates and accepts respondent's conduct. Respondent demonstrated he will abuse his status as a physician to harm others. He's done it not once, but twice in this case. The only question is whether the board will give him the opportunity to do it again. The state has been firm in its position from the beginning. The hearings officer is thorough in its legal rationale and application of the case law established by the Hawaii Supreme Court, applied by the tribunal, and adopted by this board, and is clear in its recommended order. Respondent is not fit to be vested with the power and privilege to practice medicine. Accordingly, revocation is not only warranted by respondent's egregious conduct, his unrepentant posture throughout these proceedings, and the lack of any mitigating circumstances, but it is really the only appropriate sanction in this case. None of the other sanctions address the issue that is at the heart of this case. Respondent abused his status as a physician to create his own opportunity to go into the victim's home, a person who is not a patient, but a member of the community. And he manipulated the victim into a vulnerable position before sexually assaulting her. And in doing so, respondent traumatized her. He violated her boundaries, her body, her security, and the trust and confidence in respondent as a physician. And that violation of trust and confidence in respondent as a physician is not something that can be remedied with probation, fines, or even conditions. Because at the end of the day, respondent cannot be entrusted independently with the power, privilege, and status that physicians hold in the community. A person who is not fit to hold a physician's license should not have one. It is that simple. The board cannot control what respondent does. He is a convicted sexual predator who will create his own opportunities. The board, however, can control who it authorizes to be part of its community. It can control whether respondent has the backing and the legitimacy of a license authorized by the state the next time he does this. The licensing statutes authorize the board with the power to order the revocation. The state requests that the board now exercise its power and fulfill its obligation to protect the health, safety, and welfare of patients and the public alike by adopting the whole rule as it is and accordingly revoking respondent's license to practice medicine in the state of Hawaii. Thank you.
Thank you. Okay. So, Mr. Harrison?
Thank you. Thank you, members of the board, for allowing me to speak on behalf of Dr. Beckham. And I also thank you for the time to prepare for this matter. I did not represent Dr. Beckham at his trial or any part of these proceedings. And so it took a while to get familiar with all the facts and circumstances surrounding this matter. So I thank you for that time. One of the things that we treasure in this country of ours, and specifically in the state, is the right to have a full, fair, and impartial hearing, to have a level playing field when we are brought into either court or administrative proceedings such as this. And I would argue that Dr. Beckham never received a fair and impartial due process proceeding in this matter. And that's what we're asking this board to do, is to allow him to respond to the allegations such as the DCCA counsel has offered today against him relative to the facts of this case. He never got a chance to have that level playing field and have that due process in these proceedings. And so at the outset, before addressing some other issues, I'd like to ask this board to consider remanding this matter back to the hearings officer to allow Dr. Beckham to have that fair opportunity to represent to the hearings officer and ultimately to this board the facts and circumstances surrounding this matter, and give him the opportunity to present evidence to support his position on this case. It's my understanding, and again, I was not involved in this matter previously, so I'm taking the representations that I have reviewed on the records that I have looked at, as well as conversations I've had with Dr. Becker, that he was told in his initial meeting with the hearings officer that he did not need an attorney, that he could proceed without an attorney. Now, Dr. Becker has had a long and tortuous road in getting to this point. He had expended vast resources and representation at the trial level in the criminal case, and was without resources to actually hire counsel to assist him at the earlier junction in this matter, thus did not have counsel. So when he was explained that he did not need counsel, he took that at face value And one of the things he was unaware of, because he's a doctor, he's not a lawyer, is all the specific procedures that are required when you proceed in an administrative hearing such as this, and such as the hearing that was set before him previously. He was not aware of the procedural aspects of the rules with regard to proceedings such as this. He was not aware of the civil proceeding rules, circuit court rules, the APA rules with regard to these proceedings as well. He was not familiar with the proceedings with regard to motions for summary judgment. So he was not properly prepared to proceed in this matter. And when the motion for summary judgment was filed against him, he did not properly respond. And again, this is where I ask that he be allowed to have a level playing field, because he was going up against the resources of the state, counsel who was prepared, counsel who was aware of the rules, and he was not. Now, he may have missed some deadlines in this matter, or misread or misinterpreted his responsibility to those deadlines, and therein lies the problem. Because he was told he did not need counsel, he assumed he could take on this very onerous task of preparing for this matter and representing himself. And I would submit to you that any failures that were incurred as a result of his not being aware of the proceedings in this matter and properly proceeding and responding is based on the fact that he was in effect told that he did not need counsel. He does have counsel now, and I believe that it would be appropriate for this board to consider that he be allowed to again respond to the facts and circumstances surrounding this matter properly, so you will have a full and fair opportunity to make an appropriate decision based on all the relevant facts, not based on a one-sided submission of facts. The DCCA Council has asked this board to refuse to allow consideration of filings that were made that were beyond the time frame allowed under the rules that Dr. Beckham has filed. And so he has no basis, I have no basis to submit any additional facts to you. The DCCA Council argued that the individual in this case has been violated by Dr. Beckham, and our position has been throughout in his entry of a not guilty plea in this matter that he is innocent until proven guilty beyond a reasonable doubt. Now, there has been a judicial order in this case. There has been a jury verdict in this case. However, as everyone knows here, that Dr. Beckham has appealed that verdict. And one of the things that happens when you appeal a verdict is you ask the court for a stay of minimis, that is, stay of the actual sentencing in this matter. And the court has to go through a couple of factors before they allow for a stay. And one of the factors are danger to the public. The court has to find in this instance that Dr. Becker is not a danger to the public to stay in position of a sentence in this case. The imposition of sentence was stayed as a result of that. So any allegation that he's a danger to other people at this point in time, if we take this to its logical conclusion, is that there is an order from a court in this matter that he is not a danger. Otherwise, he would have been ordered to proceed with his sentencing pending appeal. Now, again, I have not been his counsel during the course of the trial proceedings. I've had a little bit of information concerning the trial proceedings through the pleadings that were filed with the Supreme Court to have this matter reviewed and reversed. And I can tell you from at least the pleadings that I've seen and the evidence that has been submitted as part of the pleadings, that Dr. Becker has a very excellent chance of having this matter reversed on appeal based on some problems that happened during the course of the trial in this matter, as well as pretrial proceedings, technical proceedings with regard to the pleadings in this matter, as well as some post-trial evidence that has been uncovered as a result of post-trial discovery in this matter by subsequent counsel. So there's a significant basis here for the overturning of this conviction, and that should play heavily into the thought processes of this board as to whether Dr. Beckham has had a fair and full opportunity to present his case to the hearings officer. So I'm not going to waste any further time of this board in making any further arguments in this regard, but I think that what you have to decide is whether you're going to allow proceedings to go forward against an individual whose livelihood is at stake, who has entered a not guilty plea in a case and has asked that the state properly, if they are going to convict him, properly convict him, whether you should have these proceedings go forward with and under that cloud in this matter. And so we're asking this board to search the records in this case, but also search your hearts. What would you like to have in our state here? Would you like to have proceedings in which an individual is not entitled or allowed the defense, a proper defense in a case? Or would you like a proceeding in which matters become rubber stamped by this board based on a one-sided determination of the case matters in this case? So we're asking this board to strongly consider remanding this matter back for a full and fair opportunity to prepare a record for Dr. Beckham in this case. Thank you very much.
Okay. So let me open this to counsel for the petitioner. Ms. Yonashiro, you want to 10 minutes for a rebuttal?
Objects to those arguments. With regards to the argument that he's not a danger and that that was somewhere in the record, that was not in this record. And there's no evidence to support that, and it wasn't offered. With regard to the argument that he wasn't on the same playing field, that he didn't have the same opportunities, the record does not support that. Respondent had the full opportunity to present his case, including any evidence, but failed, or any evidence of witnesses, but failed to do so. Respondent failed to demonstrate that there was a genuine issue of material fact, and he failed to show that the cited case law didn't apply. So he actually had his opportunity, not just to respond to our petition, to our motion. He was even allowed to supplement the record after the deadline, and he was given the full opportunity to be heard at the hearing. So the hearings officer acted within its discretion and adjudicated the case in granting the state's motion for summary judgment. So the evidentiary hearing is not necessary. The Hawaii Supreme Court established that compliance with HRS Chapter 91 and the administrative rules of practice and procedure constitute due process. Due process is satisfied when respondent is provided notice and the opportunity to be heard at a contested case hearing in accordance with HRS 91, which respondent had on June 26, 2024. So the respondent was given that opportunity and he was given the reasonable notice. So due process has been served. And the state thoroughly addresses that in our written statement in support of the HORO. Now, with regard to the pending appeal, the state's position is that the pending appeal is irrelevant and has no bearing on these proceedings. Under Louis versus Board of Medical Examiners, the Hawaii Supreme Court addressed the issue exactly that is being argued here. A pending appeal does not have any effect on, nor does it negate respondent's convictions. For purposes of these disciplinary proceedings, he has been convicted, and that is final. And giving any consideration to the merits or even the status of a pending appeal would demonstrate that the pending appeal actually does have an effect or negates the convictions. And that contradicts established case law. Respondent fails to cite any case law that overrules or contradicts Louis. His argument has no legal merit and should not be considered by the board. And while the state understands he is standing by his innocence, there's already been a conviction by a jury of his peers, which means they have found beyond a reasonable doubt that he did not sexually assault her once, but twice on both counts. Any argument regarding respondent's innocence or the complainant's credibility is irrelevant for purposes of these proceedings. As the state has previously argued in its pleadings, the only questions of fact that need to be established are: one, whether respondent was convicted by penal offenses, which he has been, and whether respondent fails to comply, observe, or adhere to any law, which he has. And the remaining elements are established as a matter of law, and as thoroughly argued in our statement and in our motion and our reply. So again, respondent's argument is irrelevant and should not be considered by the board. Now, going back to the state's objection that, there's no evidence in our record that, and I don't think it can be cited to by respondent today because it doesn't exist. There is nothing to show that there are any mitigating circumstances. The hearings officer made it clear that there are none. And there's nothing to show that he is not a danger. So going back to our argument, again, revocation is the only appropriate sanction. He has been given his opportunity, multiple opportunities, multiple continuances, multiple opportunities to bring in evidence after deadlines, evidence that was not relevant, but the hearings officer allowed it in, the state did not oppose, and he had his day. So the fact that respondent has now retained counsel, and again, there's no record that he was discouraged from obtaining counsel. In every step of this case, whether in the pre-hearing conference or at the hearing itself, or even in the notices of hearing, it makes it clear that under the rules, respondent has that right to an attorney. So his decision not to hire an attorney does not allow him to delay these proceedings and to send it back when the hearings officer's horror is clear. He violated these statutes. There's no question. So the state requests that, respectfully respondent's arguments not be considered, yet consider the harm to the community. And again, we ask that you revoke and exercise your power in protecting the public by revoking his license to practice medicine. Thank you.
Thank you, Ms. Yonashiro. Mr. Harrison?
Thank you. One of the things that DCCA Council continues to exhort to the board is that there's nothing in the record. There's nothing in the record. And what we're asking this board to do is allow Dr. Beckham to make a record, a proper record. The DCCA Council argues that there's no mitigating circumstances and no mitigating evidence in the record. Clearly, there is none because Dr. Becker was not allowed to make a record. And that's basically what we're asking this board to do, is to allow for a proper record to be made and a proper hearing with counsel representing Dr. Beckham. That's all he's asking, is a fair opportunity for a level playing field. That's all. Thank you.
All right, thank you to the petitioner and to Mr. Harrison. So what I'd like to do now is recess under Chapter 91 into adjudicatory session, and the board will take all arguments under consideration and render a decision today.
Thank you.
And we will make the announcement in open session.
So board members, just be patient. They're moving us to the breakout room.
Thank you for always telling us what's happening, Lonnie.
All right, we're back in open session, and so I'd like to take a quick roll call of the board members. So I'm Danny Takanishi, Oahu member and current chairperson. I'm present. Mr. Gary Belcher,
Present.
Dr. Andrew Fong,
Present.
Dr. Elizabeth Ignacio,
Present.
Dr. Angela Pratt,
Present.
Dr. Rebecca Sawai,
Present.
Dr. Jerry Young,
Present.
and Dr. Brian Hatton.
Present.
Okay. So the board, after hearing from the counsel of Curtis R. Beckham, MD, and from the attorney for the petitioner, the DCCA, the board has voted and has determined that it approves of the hearing officer's recommendation to grant the petitioner's motion for summary judgment and to immediately revoke the licensure of Curtis R. Beckham, MD. And so if can entertain a motion for the board to enter into executive session.
So I moves.
Thank you, Dr. Swai. Is there a second? Thank you, Dr. Young. All those in favor for entering into executive session, please raise your hand. Okay, it is unanimous, so I'll not take a roll call. So we will reconvene in executive session. Okay, we're back in open session. And so I want to just take a quick roll call again for the minutes. So I'm Danny Takanishi, Oahu member, current chairperson. I'm present. Mr. Gary Belcher,
Present.
Dr. Andrew Fong,
Present.
Dr. Elizabeth Ignacio,
Present.
Dr. Angela Pratt,
Present.
Dr. Rebecca Sawai,
Present.
Dr. Jerry Young,
Present.
and Dr. Brian Hatton.
Present.
So before we move to our applications for licensure, is there any public testimony?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Okay. All right. So on the matter of the applications of physician for physician licensure, the first on the agenda is Dr. Catherine Samuels Urim. If I can entertain a motion.
Fong here. I move to approve the application of Dr. Catherine Urim.
Is there a second to that motion?
Young, second.
Okay, thank you, Dr. Fong and Dr. Young. Any further discussion? All those in favor, please raise your hand. Okay, thank you. It is unanimous, so I'm not going to take a roll call. And then on the matter of the application for licensure for Dr. John Paul Burns, if I can entertain a motion.
Belcher, motion to approve the application for John Paul Burns.
Okay, thank you, Mr. Belcher. Is there a second?
Patton will second.
Okay, thank you, Dr. Hatton. Any further discussion? Okay, there being none, all those in favor, please raise your hands. Dr. Pratt? Okay, thank you. It's unanimous, so I will not take a roll call. And then on the matter of licensure for podiatry, Dr. Neil Patel, if I can entertain a motion.
Dr. Young, I move to defer the application pending availability of the applicant to appear before the board.
Okay, thank you, Dr. Young. Is there a second?
Belcher, second.
Okay, thank you, Mr. Belcher. Any further discussion? There being none, all those in favor, please raise your hand. Dr. Pratt? Okay, all right, thank you. And now moving on to the ratification list that's before you, dated November 14th, 2024. If I can entertain a motion to approve the ratification list.
So I move to approve.
Okay, thank you, Dr. Sawai. Is there a second?
Ignacio, second.
Thank you, Dr. Ignacio. Any further discussion? All those in favor, please raise your hand. Okay, thank you. Carries unanimously, so I will not take a roll call. Okay, so on the moving now to the unfinished business, as all will recall, when this came up at the prior meeting, staff was going to do additional research on this matter. And so you have those documents before you. And so I'm going to open it up for discussion. And you do see in your packet of materials, this has to do with the question related to administration of vitamin injections and to the public and whether or not this falls under the practice of medicine. And if so, should the provider be licensed as a physician or physician assistant? So comments from the board? Mr. Belcher?
I was just going to say that I would think that a formal physical exam, history, and diagnosis, probably including blood tests, should be required to administer anything via IV. So if the person taking care of this is licensed, then I think it would be fine. Otherwise, I think it's questionable, unless, of course, the licensed individual was directly supervising an individual that also had the credentials to use an IV.
Mhm. So based on 453-1, I would be in agreement with you, particularly given that you are one of our public members. Other thoughts from the board?
This is Dr. Young. I agree
Yes.
with Mr. Belcher.
Mhm. And I just would like to add, as one who's involved for disclosure, like many of us on this board, with both medical education, i.e. medical students, and resident education, and in my domain of surgery, we also would not necessarily let these individuals, without some form of supervision and or training, simply inject. So this would be entirely consistent, I think, with what Mr. Belcher had said. But open to other thoughts from other members of the board? Dr. Sawai?
I was going to say that there are many vitamins that we give in a therapeutic capacity where I regard them as a medication, such as different vitamin Bs and vitamin K. So I would support regulating this practice.
Okay. All right. So for the executive officers, my understanding, looking at these materials, is this came as a question for clarity, I suppose. But my sense and interpretation of our statutes is that, and for what I've heard, I've not heard any dissenting opinions from any members of the board. And based on the materials provided to us, that we believe that this would fall under the practice of medicine, and accordingly, such individuals or providers of such services should be duly licensed. Did I summarize the sentiment of the board?
I agree.
Okay, I'm seeing all nods.
The decision of the board is an informal opinion issued
which
pursuant to,
which is why I did not take a vote.
okay. But it is pursuant to HAR section 16201-90.
Mm-hmm.
Okay, thank you.
All right. Okay, any comment, any public testimony on this matter before we move to agenda item 5B?
Thank you, Chair. We do not have anyone requesting to provide testimony.
Okay. All right. So agenda item 5B, I am going to turn this over to Mr. Randy Ho.
So this is an update in regards to the implementation of the Interstate Medical Licensure Compact for the state of Hawaii. Mr. Dave Clark, who is the operations manager with the IMLC Commission, was kind enough to fly over to Hawaii in person and to train the DCCA-PVL staff members and the mechanics of reviewing and approving IMLC applications for medical licensure. And so he spent a couple days with us and walked us through the processes that we would need to go through in order to review and accept applications. And then we also touched upon other aspects that we are currently in progress with, of establishing the internal systems that we need to have in place in order to go live with IMLC approvals on our end by January 2025. And that's the update for that.
Any questions from other members of the board? Dr. Ignacio?
How much of this are we allowed to share? Is this report, since it's been presented here in the public forum, are we allowed to share?
Well, my understanding, and we have the executive officers and Shari Wong to correct me, is once the application materials are, or once these materials are here for our review, it is a matter of, I guess, public access.
Thank you.
Because all of our agendas have to be noticed. And prior to, we have actually had to, in the past, reschedule at least one meeting, to my knowledge, because we erred in making clear what those who needed certain types of access, we weren't clear in our noticing of the virtual agenda. And so the Office of Information Practice, I believe, was the agency that required that the board cancel and reschedule that meeting. So this is a matter of, at this point, public knowledge. Okay. All right. Any other comments on this from anyone? Mr. Belcher?
Yeah. I wanted to thank Randy for putting together this document regarding the 2 days of experiences that he had. Appreciate it. I got some information out of here that I didn't already know. And I was wondering if, Randy, do you think that we're going to be ready to go live with this in the very near future, like in January?
That is ultimately the goal. We are very much working diligently to ensure that would happen. But with anything that touches multiple departments and to include IT systems, there can be hiccups. So there's no real guarantee, but that's what we're shooting for.
So I do have one question. Are there any challenges potentially with background checks? And these are of applicants.
We have submitted a bill to attempt to implement what would be called criminal record history checks, which are the equivalent of background checks in the state. And we're currently in progress with trying to get that legislation.
Okay. So would that be then a potential hurdle for implementation of this in January of 2025?
It would not affect our ability to come online in January 2025 with aspects of participating in the IMLC. And so there are essentially two primary states of participation from a state board perspective, or states. One is to be a state of primary licensure, and the other one is to be a non-state of primary licensure. So currently we are a non-state of primary licensure, which means that we do not have the ability or the authority at this point without background checks to be the state that does the initial review of applicants who wish to participate for compact licensure. We can only review applications that we receive from applicants who have gone through other states for compact licensure. And this in some ways can impede other functions of the state board. For example, sanctions would be one area that would be limited in functionality, not being a state of primary licensure.
Okay. All right. Any other questions or comments? Okay. This is exciting because more and more states are joining. All right. And it's meant to assist with physician shortages, particularly during times of exigencies and challenges. Okay. All right, the next one I'll speak to. So this has to do with the Advisory Commission on alternate licensing models. There's actually a mistake at the top because the commission is not on additional licensing, but it's alternate licensing. So it's not meant to provide a second system, but it's another model. And so what happens is this commission was put together in combination with three entities. I think I might have mentioned them before. The Federation of State Medical Boards, because that's the licensing group of individuals, if you will, that are responsible for regulation and licensure. And then the ACGME, because it's the sole accrediting system of residency and fellowship training programs in the United States. And then InHealth, which is a combination of something called FEMUR, and of course, what we all know as the ECFMG. And so, and it was really the ECFMG component that was important because they're the ones that first vet international medical grads to determine their eligibility to sit for the medical licensing exams put out by the USMLE program. And so there've been a series of meetings that were held. And so this is near the final process, looking at the draft document. And as you can see, they've looked at multiple models. And one of the reasons that this was driven was in 8 states, there is some form of legislation for additional, not necessarily alternate, additional licensing pathways for international trained physicians who do not have any ACGME accredited graduate medical education training in the US. And for a number of those states whose chairs are part of this commission, it hasn't worked out as well as they had hoped. So if you look at it, the meat of this is on page 5 in terms of the 9 overarching principles, and then the document goes into each of those principles with the rationale behind it. So of course, first and foremost, that the rulemaking authority should be left specifically within the hands of each state medical board, because again, that's the entity that oversees each state's regulatory process when it comes to licensing. And they give you all the reasons for that. The other piece is it was felt to be important that all of these individuals should have in hand an offer of employment prior to applying. And the rationale for that is that this ensures that in large part that these individuals will be supervised and it will provide the opportunity for them to be assessed to make sure that indeed that their performance based upon their training and experience will be one that respects and guards patient safety. And then the third piece is there is something called the World Federation of Medical Education that puts out something called the World Directory of Medical Schools in collaboration with the WHO. And what happens is that these individuals would have had to have come from such schools so that there's some recognition of the quality and the breadth of the education that they have. And there has to be, even outside of the United States, some completion of postgraduate training. And then all the reasons for that. And then they have to be licensed or registered or authorized, depending on the jurisdiction that they're in their country of practice. And similar to what all medical boards do, like whether it's for endorsement, licensure by endorsement, there's a limit on the time out of practice, whereby if they're outside of that time period, they're not going to be eligible to apply for this process. And so, anyway, and then of course, the requirement for ultimate eligibility at some point for full and unrestricted license once they pass certain reporting metrics. So anyway, the comment period is open until December 6th. So this document has been shared widely across all of the medical boards, but it's been sent to hospital associations, for example. So it's been made readily available. So this is another document that the Federation of State Medical Boards does want to be shared broadly. And they're still soliciting comments up through December 6th. And then there's going to be a final meeting in January where they will then they'll collate all the final comments before then. And what will happen is come up with and decide upon a final document that's going to be put out for all of the different medical regulatory jurisdictions and their state legislatures for the formation of statutes. Okay, and so I'll just stop there. Any questions, comments? All right, I think it's a step in the right direction. Mr. Belcher?
I think something like this, it's obviously necessary, otherwise it wouldn't be gaining the momentum that it's gaining. But the way I see it, to do this right, it would almost require that there be some sort of, it would be almost like a residency program. You've got to have observation, evaluation, promotion, probably would require a lot of administrative support. The supervisory people, the supervisory physicians would need to be trained in actual supervision, although I'm sure they would be pretty good at it already, having gone through training. But it sort of needs to be formalized. Those people, the faculty, would have to be remunerated in some way. So it looks like a residency program, and it probably would be helpful to have someone overseeing this to some extent nationally, like the FSMB, or maybe the ACGME. I'm not sure. I guess they have enough work, but that's kind of how I see it. I think it's necessary, but it's a huge undertaking to do it right.
Yeah. So we've gone back and forth. So Dr. Nasca from the ACGME is a member of this commission. Mary Klingen-Smith, who's the ACGME's chief accreditation officer, also sits in as part of the staff for this component. So they've gone back and forth. ECFMG, of course, is a big player. And so Eric Holmbold, who's the president and CEO, who was the senior vice president of the milestones part of the ACGME, is also a member of this committee. It's pretty broad. And so they've gone back and forth, and I think their sense was that they would be, and this would be under, I think, number 9, that they would be under what they would refer to assistance provided by these partner organizations. But when all the dust settled, and Dr. Hank Chaudhry is part of this, as the president and CEO of the FSMB, they felt that probably the thing that made the most sense, and again, it's not to put the work on the medical boards, but that the data should be kept in some repository within the realm of each medical board, because the medical boards, they felt, were in the best position to monitor such physicians. And of course, the other piece is these physicians would have to be credentialed within the institution that's offering them employment, right? And that's why the employment is another prerequisite. And again, what they're doing is, and there's legislative people, because what they're doing is this is meant to create a template for legislation in each state, with the idea that the legislators would look at this and understand that in order to provide this opportunity, if you will, or this mandate, that there would have to be resources allocated to the various medical boards in order to be able to be the repository of this information. So it's been a long process. They've had a number of meetings over the years, over the current year. Yeah.
So what's happening with ACGMEI? Are they a player? Are they someone that could really provide a lot of help with this?
They can provide help. John Aragui, I think, is the current president and CEO. So he was invited to one of the meetings, but they wanted to be very clear that because the number of programs that are accredited by ACGMEI is not a huge number. So what they want to do is they want to be sure that they open it as broadly as possible, because a lot of the ACGMEI programs would be like in Singapore, in the Middle East, because part of it is resource intensive. But there's a lot of countries, for example, that don't have ACGMEI, like Australia, New Zealand, parts of Europe, that actually have sound systems, or at least deemed to be sound systems by the World Federation of Medical Education. So one of the senior vice presidents of the World Federation of Medical Education is also a member of the 21-member commission, the 17-member commission. So all of this feedback came in as to what is the best approach that was inclusive enough, if you will, but not too broad, to make sure that there was going to be some semblance of, I guess, rigor in the process of ascertaining and monitoring competence.
Thanks,
But great
Dr.
question.
Takanishi. Thank you.
Great question. Okay. All right. So the input, by the way, the FSMB has a website. So you can actually go directly on it to provide input, or you can send it to Randy or Alani or both, and then they can submit that into the Federation if there's any input that you'd like to provide. Okay. All right. The second one is the policy on physician illness and impairment towards a model that optimizes patient safety and physician health. And so you can see this is here. And one of the reasons why I thought it was important to revisit this, this is the work group that I was part of. And so one of the things that we had started, some of you may recall a while ago, is really to look at the questions. And so something I'd like to resurrect. Look at the questions that we ask in our application and become more aligned with what's gaining traction nationally in terms of some of the lines of questionings that we have. And again, this work group involved not only medical board representation, but representation from the American Society of Addiction Medicine, the Federation of Physician Health Programs. It was a pretty broad base, and it went through the entire federation's House of Delegates and an approval process to put out as a blueprint. And so I know we were laden with work over time, so we could never, we didn't continue it. But remember, RICO had provided some inputs, and so we were going to make sure that anything that we decided was going to be aligned with what RICO also felt was important in what we asked. But the reason why it's on there is I wanted to raise that I think it's a good time to revisit the process that we had prior engaged in, to look at revamping some of the questions that we ask on our application form. So comments? And it's the questions specifically related to substance use type disorders. Questions from anyone? Good, bad, yay, nay, worthwhile, not worthwhile?
Hi, Dr. Takanishi, Lisa Ignacio, and I definitely support this and would, I appreciate all of your effort this far on the topic, because I do think it needs to be carefully looked at and be thoughtfully considered for our white physicians.
Thank you. This is Jerry. Representatives of Bulapau did meet with Dr. Takanishi. It was myself and Dr. Angela Guff in support of some changes. So, Danny, are you suggesting to have another group, since I think a few of the members on your work team are here?
The board had already started looking at it.
Okay.
And we had at board meetings, we had actually discussed it already. So this is not to be honest, this is not anything new. This is just something that became back burner because of all the work and that was going on in applications that took up the time. And as you know, we are limited based on sunshine law. 4:30, it stops. And so it's made it difficult, but work has already been done. And so my thought was to continue that work, if you will. So that's where we are. And I think I'm open to suggestions as to how best to do it. And maybe I should ask our executive officers for input too. And probably Alani, you've been here for a while, so your thoughts on how best to triage this, knowing what the workflow is for applications, and knowing the time process it takes to change an application, in terms of the state approval process. Your thoughts, I think, would be helpful here too.
Thanks, Dr. Takanishi. So what I can do, and Dr. Young, you were correct, there was an established group. It included Dr. Takanishi, Dr. Jaffe, Mr. Belcher, and Dr. Bjornson when he was with the Physician Health Program. They completed some research on the issue. They looked at other state applications, their questions. They considered how to best amend the 2 questions on our applications, one for initial licensure and one for your renewals/restorations. What I can do is I can provide all of the research again to the same group, absent Dr. Bjornson's input, and we can discuss that information. Look at amending the questions, Dr. Takanishi, if you're okay with that, and Mr. Belcher, and then present to the board your research and possible amendments to the 2 questions posed.
Okay? That sounds really good. You might consider asking Dr. Angela Guff. She took Dr. Bjornson's position to be part of the group.
I could do that. Great. Are you okay with that, Dr. Takanishi and Mr. Belcher?
Yes.
Okay.
I have one additional. Go ahead.
Go ahead.
Alani, and maybe Sherry, do we have to go to the legislature to change the questions on these applications? Okay, good.
To change the law,
yeah. So for your initial applications, just procedurally, it's a little easier to change the question itself. On the renewals and restorations, those questions are used across several different areas. Little revisions or amendments depending on the profession. So that may take a little longer, but we will try and align both questions as best as possible.
Thanks.
Mm-hmm.
And the other thing too is, I think some of you already know it, but the Federation of State Medical Boards are very happy to help if we, if we express interest to them, because they've assisted some other states in doing this, and some of the other states too. Board members, South Carolina Medical Board, they've gone through this and stuff. So, and I think the nice thing is we're not going to be the first board. So in contradistinction to the alternate licensing or additional licensing models that 8 states have implemented in some form, and at least 4 of them who've had it implemented a little longer have come forth and said, hey, you know what? This isn't working the way we had intended it to work. And so now there's this deliberative process of this commission. But for the revision of the questions related to substance use disorder, I think that the boards that had representation on this work group felt very happy and still continually do in terms of the fact that this has not in any measurable way affected public safety.
This is Jerry again.
Yeah.
I just wanted to thank Dr. Takanishi for your leadership on this issue. Buried in here is the fact that you're the work group chair for this, the FSMB work group on physician impairment. So thank you, Danny.
Well, they probably stuck me in there because they probably figured I was the one who knew the least about this stuff. And but it was a wonderful eye-opening experience. The chair is not based on expertise. The chair is based on the facilitator role. The expertise was everybody else, but I was very educated. It was a great experience. And so, and then the other thing too is they're very data driven. And so I thought that was a wonderful process. And so because the year is coming to a close, I thought there's probably some things on the back burner that would be good to look at, because I think the Interstate Medical Licensure Compact was a big deal, and the legislature supported the board, and Alani did a lot of work to put all of that together, to make sure that they understood and they were educated, and then so that now has gone into law, and now it's the other hard work, to the implementation process. But this one then is sort of the other unfinished business. That's important. And again, there's data out there that shows that it's very important that not only do we self-regulate as physicians, but that we create the safe haven so that physicians are comfortable with the disclosure. And then again, I'm comfortable because they do have data out there that physicians under treatment can render wonderful care. And so all of this to me dovetails along with the advisory commission and alternate licensing models to look at how can boards from a regulatory standpoint address the healthcare shortage needs by maintaining either physicians in the workforce or allowing safe physicians to enter the workforce. That again addresses some of the issues, again, in a very deliberative, but in a very responsible way. And so to me, I think this all kind of dovetails. And then I think it also is an important piece for us to look at, because it's our little contribution to the public, particularly for access and barriers to care, again, in a way that guards public safety. I mean, I think that's what it's about. Dr. Ignacio.
As I said before, I'm grateful, and your humility in this service is it's touching and it's inspiring. Thank you, Dr. Takanishi. I do appreciate how you're just like, oh, it's just not me, it's other folks, but thank you. I wanted to say also that I don't want to introduce any conflict or bias, but if there is any need for the board to have advocacy in place for these measures, please let us know, as Dr. Pratt and myself, as we are on the executive leadership for Hawaii Medical Association. And we just returned from AMA. We were just there this past week for the interim House of Delegates, where several states talked about their different safe haven programs, particularly Virginia, and how that interfaces with licensure and the need to revise these questions and make sure that we also provide opportunities even at the time when they apply for licensure. It may be one of the first times they have to confront the fact that they have to disclose this information and how to do it best while still getting help. So please let us know. We're happy to be resources and voices for you in all of this effort.
Thanks. And the other thing too I should mention is, interesting, over the years that I've done things with the Federation of State Medical Boards, there are a number of medical boards where the appointees come through their state medical associations. Hawaii is a bit more broader, but the processes are very same. In many states, it's gubernatorial nomination process and then vetting through some Senate related process. Yeah, but that's great to know. All right, so moving right along, the last piece is an ask from the United States Medical Licensing Examination Program. It's agenda item D. And so as many of you know, the United States Medical Licensing Examination is governed dually by the National Board of Medical Examiners and the Federation of State Medical Boards. And that's why it's an MLE, or Medical Licensing Exam. And these are requirements for all students who graduate from allopathic schools. No different than something called the COMLEX is required for licensure for all students who graduate from osteopathy schools. And so what they're looking for is they are looking for, you have it in your packet, individual volunteers to serve on any of these committees. And the only criteria is an individual had to have been a current or former physician board member. That's it. And it shows you the level of commitment. So it can be anywhere to test development committees, and like they said, 40 to 50 hours a year, or it could be a standard setting panel, one-time meeting with some prep work. Okay, so this is for your consideration, and they're seeking volunteers. And should you decide that you have the time, then if you can just let our executive officers know, and they will submit your names. And I can say personally, way back in 2007, I had my name put in, and then they invite you to like a 1.5 day meeting. You can see how they create test questions and things. So I've actually been involved in that program. It's a wonderful program, and you do get a fair amount of CME. And so early on, when I was on a test development committee, I remember one year I got 40 CME credits. But you actually really, like they said, 40 to 50 hours a year, you actually really do put in that amount of time. Okay. Now, later on, of course, I don't, but this is like 2007, 2008. So it was a wonderful opportunity. So, and they're always interested in medical board representation. Okay. That being it, I don't think we have any other, Mr. Brosh, I just wanted to check. I apologize that I had computer glitches, but I just wanted to check for my own edification that you all were able to approve the minutes. Okay, so from what I'm seeing, we have nothing else on the agenda that needs to be covered. Is that correct? For the section I missed, Mr. Belcher.
Well, Dr. T, we approved the minutes with some modifications that Dr. Sawai pointed out. So yes, all good.
All right. Okay. From our executive officers, any other items other than the December 12th meeting?
I don't have any, Randy.
No additional items.
All right. So to all on this meeting, thank you very much for your time, and to all that are present, happy Thanksgiving, and we'll reconvene as scheduled and as noticed, December 12th, 2024. Okay. So thank you, everybody. The meeting, I'm not going to take a vote. I assume it's going to be unanimous, but the meeting is adjourned.
Thank you.
Thank you.